Well, ours is fairly brief. We have 2 pages that we've given to everybody. The review the universe of 402 agencies. I realize that's 2 more than Finance indicated. Final reports issued, 125. Reports that are in progress, 160. Total dollar findings, 3.7 million, or billion, I should say. Anticipated completion date is December 31st, 2014. The common findings that we have, we find unallowable transfers of fixed assets, buildings, property, parks, etc., to the city or the county, or the city or county, or other local agency. And generally, these other local agencies are EDCs. We have transfers of housing assets, including low-mod assets, directly to the housing agency. We found assets not transferred, still on the former RDA books, to the successor agency. And we found other unallowable transfers, cash transfers, including bond proceeds to the city and county, or other local agency. That's basically our plan and where we are right now.
That's your report.
Pardon?
You're concluded. Okay. All right. So then I want to bring up the other panel while we're asking the questions, and if you all don't mind staying, because I'm sure additional questions will happen. So if we could have Aaron Laurel and Patrick Whitnell come up and sit over here. And if, I'll start, and then please we'll see who else is interested in asking some questions. The Department of Finance, you presented what I think would be a rather rosy picture. However, it seems that, well, it doesn't seem so rosy to me, and I'll say why. You mentioned the number of lawsuits and what judgments have gone against the state. And so if we just take pure numbers in terms of number of lawsuits and number of rulings against the state, you know, it would look like, you know, we're doing pretty good. But the more significant thing is, what are the judgments? What is the value of those of the judgments that were against us? And as is pointed out in one of the last slides, we have potentially $3.4 billion at jeopardy. So that could skew things some. There's additionally, what are we spending on these lawsuits? So that's a concern I have. But the bigger concern I have is that if we're trying to move forward and have a smooth process, get this resolved, and you mentioned again optimistically that there's so many that have been approved and such, but it also is still the case that we have 230 agencies that have not sued, that have submitted their long-range property management plans and are trying to cooperate, trying to, would appear, follow the rules, and yet only, the numbers I had were 48, but you've clarified today 65. Only 65 have been acted on by the department. So I'm wondering, and you can respond to both. First, the cost of these lawsuits and how much of this money is in jeopardy. But then, secondly, the issue of, is there, one could look at this somewhat cynically and think that the Department of Finance is dragging its feet purposefully because within the legislation, if there's not action by the end of this year, many jurisdictions are going to have to, or rather RDAs, are going to just have to get, sell their properties. So if you could respond to those.
Sure, thank you. I'll start with the first one about the lawsuits. I think to clarify, while there is risk and financial risk associated with these lawsuits, the lawsuits that have gone against us are constitutional questions for which finance really has little role in. The constitutional was whether or not the legislation was drafted in a manner that passed constitutional muster. So while the AG's office is up there representing us, there's really little we can do if a judge thinks something violates the state constitution. That's going to be their ruling. As it relates to the property plans, Did we get a slow start? Yes. There's no doubt that we got a slow start. I can tell you we have yet to miss a deadline, and I don't plan on having that happen here. I have no doubt for those agencies that turned in their plans, we will get them an improved plan before the deadline ends. We have instituted timelines internally to help us with that process. We do have to take breaks in between to manage the ROPS process, and then we come back to the property plans. But the property plans are our #1 priority outside of when we're in a ROPS cycle. And I have no doubt, and I'm committing to you, that we will get those done for those who turn them in before the deadline passes. That is our goal. We are not dragging our feet, and we've never dragged our feet. We have essentially gone from one process to another nonstop in the last 18 months, whether it's from HATS to a DDR to a ROPS to another DDR, back to another ROPS. It has been nonstop from review to review to review to review. We do have to have staff to take time off. We do have, a work-life balance we're trying to maintain in order to retain staff. We authorize overtime where appropriate, and I have no doubt that we'll get through all these plans.
Just not to dwell on this one too long, but given that you raised yourself issues around, people have legitimate needs for leave, there's, vacation time, sick time, whatever. By my calculation, you'd have to approve one every third day to meet that end of December deadline. And given the amount of time the approval process has taken so far, is there additional staff that would be brought in, or have you streamlined the process of approval?
So one thing we're looking at is within our Office of State Audits Evaluation, while we're working on the ROPS, we're seeing if we can move staff over to help with that process. But it's really not as much as you think. If you consider when we review a recognized obligations payment schedule, we have a 45-day window to review and approve 385 issues. So that 230 between now and the end of the year is definitely possible, and we expect more to come in. So many of these are already well underway in the review process. More will be coming out, in the next few weeks. So I think it's doable, and nothing. I haven't seen anything yet to indicate any worry on my end that we won't be able to complete these between now and the end of the year.
Actually, I spoke too quickly. It would be every 2 days, not every 3 days. But back to the amount of funding that's at jeopardy due to the lawsuits. Mm-hmm. I know there's constitutional questions, and I know that we have to, but we're still in a circumstance where if the rulings don't go in favor of the state, we have a good deal to lose.
Right, and so the question will then become, what happens? I think that's the thing that everybody is looking at right now. You could have do more entities all of a sudden start suing and saying, hey, I already paid, yet this court ruled that something was unconstitutional. How do I get my money? I don't know the answer to that right now. The lawyers don't know the answer to that right now. That's going to be a messy situation if that were to actually occur.
Well, seems to me all the more motivation for us to try to move these along. Yes. So I have, in terms of people who wanted to ask questions, are Ms. Atkins and Ms. Harkey, Mr. Jones Sawyer. So Ms. Atkins.
Thank you, Madam Chair. Mr. Howard, let me follow along on a couple of those, because it sounds to me like what you're saying is, given the process that you've been through and walking through your PowerPoint, that it seems to me like the focus is now going to have to turn into the long-range property management plans, because that's where you are. I just want to express, I too, having certainly been working with Department of Finance and the working group over time, and I am very concerned about that date. I think it's an aggressive plan. I know that resources have been put in place to try to get through this process, and it certainly has had multiple processes along the way. So I just want to put out there, I think it's important, and I'm going to be following that with you outside this process, given we've had that working relationship, and I'm very worried about it. I'm sure you're responsible for this, and you have to make it happen, but I am concerned about it. Because of the numbers. And at the same time, you're still having to get through findings of completion. It looks like you're making headway there by my count, and our numbers may be a little off based on things happening and ongoing changes, but it looks like you've got about 83 left. And in terms of the big bulk of this is long-range property management plans, and I'm sure there's going to be a lot of meet and converse in that process as well. So help me understand the process for approving, if you would, and I don't want to take a lot of time, and the reason I ask for the process for approving that plan is there's been some comments about inconsistencies around, and you have a lot of staff, but I want to understand how you deal with entities who come forward with their plan. What's the internal process? How do you see it going? How does it happen?
Sure. So the way that the Department of Finance is set up is we're set up with teams. There are basically 4 teams, and each county is assigned to one of those 4 teams, and then the successor agencies within that county are responsible for the responsibility of that team. So if we get a property management plan that comes in from one of those entities, it gets signed to the staff within that team. So within that team, we have continuity within the supervisor and the lead and the manager who oversees that process, while the analysts below, in theory, is always getting the same information for their agency to the extent they get a little bit, and let's say all their agencies submit their plans, but another analyst didn't have their plans come in. We will share the workload amongst the others to help out. We've set up our internal deadlines. So generally speaking, if there's less than 10 properties listed on a plan, we have set internal target dates, such as 30 days to review a plan with only less than 10 properties. Anything between 10 and 20, we have 60 days. Anything over 20, we have a lot. We've given ourselves up to 90 to 120 days, depending on the quantity. Now, we have some plans that come in that have up to 200 individual properties listed on those plans. So it's a lot of work to review to make sure that they've provided all the information as required in the statute for each of those properties, because that's what the statute calls for. Complicating our efforts is the fact that many of these plans get submitted in the manner in which the agency chooses to generate those plans. Unlike the ROPS process, where they have to submit things in the manner required by finance, there is no requirement here to submit these in the manner required by us. So every plan we get is different. So what one entity submits, it's written one way, versus what another entity submits, it's written another way. Sometimes we get a plan that's 400 pages of narrative that we then have to read and try to comb through and find out all the various sections. We've conducted comprehensive training of the staff so they know what to look for according to the statutes. We've even hired some consultants to come in and help us review property, because I can tell you the one thing going into this, we are not real estate experts. We don't pretend to be real estate experts, but we are learning a lot. I think it's fascinating when you look at all the various properties that are out there, the remnant properties, air rights, everything that's associated with these property plans. It's just very unique in terms of all the things that redevelopment agencies were dealing with. But I understand your concern about the date, and I'd be happy to have conversations about that. We're going to see how the process that we've put into place, to see whether over the next months it's really working and we are getting through it in the manner that we expect. Okay. And if not, we'll try to make the necessary adjustments, and we'll be happy to talk to you about any concerns that you may have, or any suggestions that you may have to help us improve the process. Like I said, one of the biggest barriers is the manner in which these plans get submitted and how they're not all the same, so that makes things difficult.
Right. Madam Chair, just as a point, a placeholder, given that we've got this year in which to get these done, and this is the oversight venue, I'll be following up and watching this as chair of the working group, but may want to touch base with you definitely after the budget to make sure that we're on task here, because it might require legislation if we don't meet that deadline. And I just want to put it out there now that that's an important factor for us to have a reasonable dissolution process and be fair to all the entities, including the cities. So I'll let you know if that's okay. Madam Chair.
Certainly, and there may be some things we ask at the conclusion of the hearing, other issues that may come out. So I'm trying to take some notes right now, so in our wrap-up, we can bring some of those things up.
Two very quick things, because I don't want to monopolize the time. One other thing that I kind of want to bring up, Mr. Howard, there is a little bit of confusion about Department of Finance requiring cities to reach agreements with counties and schools before Department of Finance will approve their long-range property management plan. Can you explain Finance's authority for requiring things called compensation agreements? Hopefully you know what I'm talking about. I've had some feedback on that. Maybe just quickly, what's your sense?
Sure. So we believe that when you read the statutes, the statute requires that the property management plans be developed in accordance with the law. Once approved, then the plan will govern. But that doesn't mean that the agency gets to build the plan outside of what the requirements in the law are. The requirements in the law require compensation agreements if the sponsoring entity wishes to retain the property for future development. We do not require that agreement be in place prior to the approval of the plan. We're more than happy to approve the plan with the mere statement in the plan of the intent to reach such an agreement. That agreement does not need to come before Finance for approval either, nor does it need to come before the Oversight Board. That agreement is between the sponsoring entity and the taxing entities. These are properties that were acquired with those taxing entities' monies, so they should have a right to say whether or not they are willing to give up those properties for free or not. And in some cases, some compensation agreements may be zero, and that's perfectly fine as well. Again, like I said, that is not for Finance to decide the manner in which their compensation agreement is reached, only that there's an intent to reach one. And then if they make that statement, we have no problem approving the plan.
Thank you, Mr. Howard. The last question, I have others, but I'm assuming other members of the committee have specific questions, but I would ask the Controller's Office, in terms of what is expected of the Controller's Office and Department of Finance, it seems to me like the Controller's Office is a little bit behind in terms of I'm trying to balance the scales here and figure out how the two of you are feeling like you're in sync and moving forward at the same pace, because there are requirements by the state, the controller and Department of Finance, and they have to sort of mesh together. And I'm getting a sense that we may be out of balance here. So what do we do to make sure, because sometimes entities get conflicting information. We talked about this last time. We had an oversight hearing between the Controller's Office and Department of Finance, so I kind of want to know how that's working, and are we going to get into a problem of one or the right hand being too far ahead of the left hand, and it's going to cause us problems at the end. And so just if you could speak on that, and then, Madam Chair, I'm done. Thank you.
Sure. It's an interesting process that we're supposed to be, I think, under AB 1X26, that we were going to be ahead of the Department of Finance's issue with regard to due diligence and things like that. As it happens, because 27 lost out, and because 1484 came in, we are behind. So we're catching up, which means that every time we issue a report, we have to go over to Finance and take a look at the documentation that they put out with regard to both due diligence reports and issues involving property management plans. Keeping in mind that due diligence reports are just the cash issues. We have like 3.7 million. A lot of that is non-cash issues. So essentially, we have to go over and make sure that we have determined what issues there are, and has Finance already picked it up and put it and in effect collected it. So. So far, I know that we had a number of issues involving a question about the use of cash to pay cities for finance agreements, and we indicated that we had a position that had to do with the fact that we determined that if a payment had been made, that those payments were not necessarily supposed to be returned. As it turned out, we talked to finance, we talked to our attorneys in both finance and Department of the Controller's Office, and determined that in fact they were supposed to be pulled back like finance had done, and so we have taken care of that with regard to all of the agencies that are had that particular issue. As it happens, so far we haven't found any new issues with regard to state agencies. We have 6 that were leftover agencies that we had done the report on, and it was completed, and we're now in the process of going back and reopening those issues to take care of those. But so far, I think, keep in mind we try to do the best we can, but so far I think we've taken care of the differences that there were between us and finance.
Mr. Howard, anything you want to add to that in terms of the?
No, I guess at the beginning that was a kind of a concern, because we were, we had what I felt like we had a lot faster deadlines, I guess, than the controller's office. So it was really making sure that whatever we were putting out, that they also had access to and availability to review, so that when they were coming up from behind and also looking at the same issues, that they were coming to the same conclusions, and or hopefully they would, in theory, catch anything that we may have missed.
Okay.
But I think at this point, I haven't seen anything to where they've caught something less than us. So.
All right, so Ms. Harkey?
Thank you. I appreciate this. It's allowing me to get up to speed. I've kind of lost track of what was going on. My fault, but there's a lot going on in this building. I understand you were put into a pretty tough box because this happened automatically and abruptly. And so I appreciate what you've done to date to fulfill your obligations. My concern is, as you know, with the local government that's trying to meet theirs. And I appreciate that Ms. Skinner and Ms. Atkins brought up the long-range property management and the need for potential legislation, so that if we're not going to meet that, we can somehow have some leeway for our local government. I've heard that and I think part of this problem with not meeting this is that you've got 550 meet and confer sessions that are held. Well, meet and confer doesn't necessarily mean that there's any progress being made. It means that you've met, you've conferred, and you've probably, and what I'm hearing is primarily ignored. And so I'd like you to address that process, which may help to expedite the long-range property management plan. Also, I would think there'd be a concern in this legislature for the sales and use tax taking, and perhaps we could clarify that with legislation as well. Because although I understand that if you're not paying, you want to grab it here, I think that being that this is a legitimate court case, and that there's money being spent on the state side as well as the city side to argue this, we might be able to make a decision here in the legislature that perhaps, in my opinion, that's off the table, because I think that those who aren't paying are probably struggling. So correct me if I'm wrong. And if they're struggling and we're taking their sales and use tax, that's like a double burden. And I feel like this was abrupt on your part. It's very abrupt on the local government. And it seems like, in certain instances it's working out and we will work through it, but we all knew that this was really sudden and that would probably not yield what we thought it would yield when it happened. So I guess my question is your feeling on the meet and confer sessions, and when you win, you lose in the lawsuits and the withholding of the sales and use tax.
Well, let me address the last piece first about the sales and use tax. I mean, obviously, finance is required to follow the law as currently written, and until such a time as A, the law changes, or B, there's an appellate court decision saying that that law is unconstitutional. So we need to go forth and just implement the law that's currently enacted. So we're going to go out and we have to proceed in the court cases until one of those two things happens. As it relates to the meet and confer process, the meet and confer process, in my opinion, works very well. While not every agency gets the decision they want, that's going to happen. We do overturn decisions, though, through the meet and confer process, and many agencies do get resolution through that process. Not every process, actually, the legislation didn't actually call for meet and confer for every process either. That's why we've implemented the meet and discuss for those other areas where agencies want to talk about determinations we made. For instance, property plans, for instance, oversight board actions. None of those things require to meet and confer in statute, yet we're already allowing agencies, to the extent they want to meet and discuss those issues, we sit down, talk with them, and meet with them on those issues. Well, I think the process has been going very well. I know many people out there here that they don't think they didn't get the decision they want, but that doesn't mean that we're not implementing the law correctly. Unfortunately, many meet and confers like to come into those sessions with constitutional arguments, with things that finance can't rule on. The city cannot come and say, hey, this violates Prop 22, you need to overturn your decision. Well, no, because the statute as currently written says this, and we need to follow the statute until such a time as a court says there's a constitutional issue. Finance doesn't make constitutional decisions. And a lot of our meet and confers, unfortunately, deal with those really high-level, broader challenges that really aren't on the merits of the law itself.
Okay, well, my meet and confers that I've heard about have been on the merits of the law itself, where the properties belong. And so in those instances, I mean, assuming that it's part of the legal process, I didn't mean to get off into the constitutionality or not, because that's being litigated. If you have a property that's in dispute, that, the city is they're saying that this belongs in their long-range property, and you're saying, no, you have to sell, what flexibility has there been in that area?
Well, a ton. I think just to clarify is we don't tell cities how to dispose of their property. They're given 4 choices, and they're to pick. So finance doesn't tell a city, no, I don't want you to retain that for future development. I want you to sell it. We don't have that authority. That's for the property plan and the city to decide. If they think it's governmental purpose, they're going to have to show that it's for governmental purpose or going to be used for governmental purpose. But if they want to use it to fulfill an enforceable obligation, that's fine too. We have many entities that want to lease out some of their properties to generate revenues to pay down their debt. That's a great idea. We have a lot of debt, as you can see from the one slide. There's still $60 billion that are owed out there statewide. But those are local decisions. All we're reviewing is to make sure that they have chosen one of those 4 options as well as complied with any of the requirements and statutes in terms of whether or not they've provided all the information associated with that property.
Well, I'd like to talk about it with you later offline, because there is
sure. If you have a specific example, I'd be happy to.
I do, and I also would like to once again announce my support for changing this legislation such that we're not grabbing sales and use tax, because I think that we've got a lot. If of the 72 agencies that have not paid their DDR amounts, 11 haven't completed the reports. Why? I mean, are they broke? Are they not able to? What are we doing? Because as our cities are impacted, the state is further impacted through social services, needs to keep things going, and our constituents are who we serve.
Sure. So of the 11 that haven't completed the report, a couple of them are the 2 cities that are in bankruptcy, so they have other things that are going on that are kind of prohibiting the ability to get those reports done. Stockton, San Bernardino, City of Bell is another one. They're history has been well documented about their issues that they're having. Some of the other ones are really small entities that, for whatever reason, just have not completed their reports. They thought that maybe they didn't need to do it because they didn't have any cash assets for which to report, but it didn't mean that they didn't have to actually complete the report and come to that conclusion. We've contacted all those agencies. Many of them are working on getting them in. Even Stockton's on the verge, I believe, of submitting their reports now that they're pretty far along in their bankruptcy process.
Even Stockton.
We do expect those 11 to ultimately come in at some point. But there's nothing that we can do on our end to hurry them up. They have to complete it on their own and then submit it to us.